Jefferson County Court at law number 2 is not in session. The court is in session with 2 dockets. We have our motion to revoke probation docket, and we have our announcement docket. Okay. Did they send a dismissal? Okay. Okay, we're in cause numbers 23 CCCR 1968, cause number M334214. Both cases established state of Texas versus Chelsea. Nicole Sams. Ms. Sams, is that your full name?
Yes.
How you doing, Ms. Sams? I'm doing fine. Thanks for asking. Now, Ms. Sams, you're represented in your case by your attorney Michael Catt. Attorney Catt, how are you doing?
I'm good, thank you.
That's good. The state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well. How are you, Judge?
I'm doing fine. And the probation officer is represented by Mr. Gary Gilliam. Mr. Gilliam, how are you doing? Okay. Mr. Hubel, I have before me two motions to dismiss the motion to revoke probations in Ms. Sam's case. Is that correct?
That's correct, Your Honor.
And I just signed those dismissals. Now, Mr. excuse me, Mr. Gilliam, does she have any more time left on her probation?
Yes, sir, she does.
So she'll still be on probation?
Yes, sir.
Okay, your probation has not terminated. And so, I just signed the dismissals. You can get a copy of the dismissals from your attorney, Ms. Sam and Mr. Catt. Once y'all get the dismissals, you and Ms. Sam will be free to go, and you have a blessed day.
Thank you.
And you have a blessed day as well, Ms. Sam. Please stand in front of the court coordinator. Okay, Mr. Hall.
Yes, sir, Your Honor. I'm here this morning for Mr. Vega. He, his doctor has furnished my office with this, excuse. He was in a terrible.
Did you give a copy to the prosecutor?
He was in a terrible accident and, several months ago, and he's had numerous surgeries. His latest one, he broke his back in this surgery. His latest one, he had, cervical spine surgery on January the 11th.
Okay.
That's a letter from his doctor. And and he's, also been taking medication. And, I would ask for 2 months, but he has been very cooperative with my office. And he is taking these cases very seriously.
Okay, I'm reading the letter. I'm trying to understand based on what the doctor says,
Which doctor is that?
whoever sent this, is it
The first letter?
somebody named Ryan Stuckey, MD? That's the doctor.
That's the one I read.
Okay, I'm trying to understand why he would be unable to make an appearance in person via Zoom or telephone if he's only having problems bending, pushing,
You
pulling,
want me to try to
stooping,
get him
twisting, or
on the phone,
lifting.
Your Honor? I mean, you want me to try to get him on the telephone?
Yeah, I think that would be
I'll
best.
be happy to do that.
I get. But, yeah. Yeah. Yes.
Speakerphone with Judge Holmes. You're in the court.
Okay, this is cause numbers 23 CCCR 1744, 23 CCCR 2291. Both cases are styled the state of Texas versus Don Henry Vega. Mr. Vega, is that your full name? We have some bond conditions. Mr. Vega, how are you doing?
Better than I have been, sir. How about you?
I'm doing fine. Mr. Vega, we praying that you have a speedy recovery from your accident. Now, you're represented in this case by your attorney, Attorney Willard Hall. Attorney Hall, how are you doing?
I'm doing okay, Your Honor.
You can set it on right there. You could just set that right. Yeah, you can just set it flat. He'll still hear the sound. And the state is represented in this case by Attorney Erica Porter. Attorney Porter, how are you doing?
I'm doing great. How about you, Your Honor?
I'm doing fine. Now, Mr. Hall, what are your announcements in Mr. Vega's cases?
Well, I understand he's making progress. He has not yet been released from his doctor. I would like to see him get that release and be off the medication so we can, before we proceed any further on this case, we can make an informed decision about what happened.
Okay. Now, Mr. Vega, your case is going to, you gonna give us a reset date?
April 15th.
April 15th, 2024. Is that enough time?
That's too much. Yes, sir.
Okay, April 15th, 2024. Now, Mr. Vega, I see, well, first of all, Mr. Vega, your case is gonna be reset to April 15th, 2024. But I'm looking at your cases, I see that you have 2 DWIs. And so these cases are pending. The court is going to give you some bond conditions. And I'm going to read these bond conditions to you. We will give a copy of these bond conditions to your attorney who will provide you with the conditions. And the bond condition states as follows: following the return of a criminal information in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply, but condition number 4 does apply. Let's see. And in this case, the court is going to require that you install an interlock device on any vehicle that you own or operate. A defendant who is whose information charging with any offense, I'm gonna scratch through subsequent, any offense listed under section 49.04 through 4906 of Texas Penal Code shall not operate any vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court. And normally we say on or before it's on or before 3 days after the day. Now, that's any vehicle that you own or operate.
Yes, sir.
And do you understand that?
Yes, sir.
Did you already get a interlock device on your vehicle?
Yes, sir. My truck has one on it.
Okay, well, just give proof to the your attorney, and your attorney is gonna send that proof to the court either by fax, email, or in person.
Okay.
Okay, and I will be giving a copy of these bond conditions to your attorney so that he can provide the copy to you. And again, court is praying that you have a speedy recovery.
Well, thank you.
You're welcome. You're free to go. Stay in contact with your attorney and your bondsman. And you have a blessed day.
Thank you.
You're welcome.
Okay, I'll hang it. I'll come in.
Okay, here you go. Hold on. Here you go.
Thank you.
You need to make a copy of that for,
Okay.
him.
Thank you.
And Mr. Roebuck, you have Anthony Goodo? Mr. Goodo?
Appreciate you taking me out.
I didn't write the name on it?
No.
Number? Yes, he has two cases. Okay, this is cause number M 331-912, case of style of state of Texas versus Anthony D. Goodo. Mr. Goodo, is that your full name? How are you doing, Mr. Goodo?
Very good, and you?
I'm doing fine. Thanks for asking. Mr. Goodo, you're represented in your case by your attorney, Attorney Tom Roebuck. Attorney Roebuck, how are you doing?
I'm good, young. Thanks for asking, and thanks for taking me out of work.
Okay, no problem. And Mr. Where is this? Okay. Mr. Roebuck, what is your announcement in Mr. Goodall's case?
Your Honor, he just, day before yesterday, was arrested for a felony. So I'm really not in a position to do anything until I figure out what the deal is with that, if I can have a reset.
Okay, let's see. I was looking to see if you had any bond conditions. Let's see.
Felony bond is.
Yeah, I know, I need to have some bond conditions in this court. On this case. Let's see. Now you need your case reset to give you an opportunity to find out what's going on in the
Yes.
in the other case that in the
Yes.
recent case he was just arrested
Yes, sir.
on. Could you give us a reset date?
We can go with, April 15th, if they haven't set a felony court date.
You say April 15th?
Yes.
Okay. Now, you said April 15th?
Yes, sir.
So your case is gonna be reset to April 15th of 2024. Your attorney's gonna get a copy of that reset. Once you get a copy of the reset, you'll be free to go, but before you do that, I need to give you some bond conditions that your attorney is gonna give to you. And I'm going to read these bond conditions to you. It's titled Standard Bond Conditions in County Court at Law Number 2, following return of information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered, subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
Now, condition number 3 and condition number 4 does not apply. However, condition number 5 does apply. It states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, you can stand over there and get your copy of your reset and a copy of your bond. Once you get a copy of your bond and reset, a copy of your bond conditions. Once you get a copy of your bond conditions and your reset, you're free to go and you have a blessed day. And Mr. Roebuck, you're free to go as well and you have a blessed day.
Thank you. Appreciate it.
Okay.
One for you. And one for the-
Okay, he needs to get a copy of his bond conditions too.
Yeah.
Who else we? Next case is cause number 23 CCCR 1708, case of Style of State of Texas versus John Edward Toops. Mr. Toops, your full name is John Edward Toops. How are you doing, Mr. Toops? I'm doing fine. Thanks for asking. I'm Mr. Toops. Last time you were in court, your case was reset on November 14th to give you an opportunity to hire an attorney. Have you hired your attorney?
No, sir, I have not.
Okay, why haven't you hired an attorney?
I just recently got custody of my son in full custody, and working on putting him on my insurance and stuff, and trying to situate him in my house, and then I'm getting, it's hard to transition into having my son around all the time.
Okay, now, so I'm trying to figure out what does that have to do with you hiring an attorney?
Tight too.
Huh?
Money's kind of tight too.
Okay, now you understand, or you aware of the fact that the last time you were here on November 14th, the court read to you what is called judge's explanation of rights to defendants without attorney. In that document, it states that you have three options regarding your right to have an attorney. Number one, you can hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. So based on what you're saying, that your money is tight, you still have the option to fill out a financial questionnaire so that the court can determine whether or not you qualify for a court-appointed attorney.
Yes,
Okay?
yes, sir.
So you want to do that?
Yes, sir.
Okay. Just have a seat. She's going to give you a clipboard with a pen and with the documents that you need to sign.
Thank you.
Okay, you're welcome. He might be. Here's a felony. Okay, next two cases are cause numbers 23 CCCR 2486 and cause number M330688. Cases are Style of State of Texas versus Ramses Concepcion Morales. Oh, he's in jail? Okay. Just hold him. Keep track of that. Let's see the next. Next case is cause number 23 CCCR 1278. Case is filed in State of Texas versus Justin Jamal Jones. Mr. Jones, your full name is Justin Jamal Jones?
Yes, sir.
How you doing, Mr. Jones?
Good, just witnessed my, daughter being born today.
Well, congratulations.
Thank you.
Okay, congratulations. Now, Mr. Jones, the last time you were here, November 14, 2023, you stated that you wanted your case reset to hire your own attorney. Have you hired your attorney?
I was gonna ask you think you can try do it one more time for me?
Now you need more time to hire a lawyer, so you have the funds to hire an attorney?
Yes, sir.
Okay, so let's give him a reset to hire his attorney. April 15th. This case is gonna be reset to April 15th. Give you opportunity to hire your own attorney. Our court coordinator is going to give you your reset date on a sheet of paper. And then once she gives you the reset on that document, you're free to go. And you have a blessed day. You're gonna have a seat in that first chair on the wall. And again, congratulations on the birth of your child.
Thank you.
You are. Oh. because I need to read this one. Mr. Ellis, this is cause number M321394. And we was looking to see if he had appeared in court before on just a regular motion to revoke probation. And now they have this first amended motion to revoke probation. So what I'm required to do is read it to you. Okay. And in this first amended motion to revoke probation that was filed by the Jefferson County District Attorney's Office, it alleges that you, Chase Wade Ellis, that you was tried on October 28th of 2022, the offense of hunting violation. The court found you guilty and assessed punishment at 90 days confinement in the county jail and a fine of $1,000 in accordance with Article 42.12 of the Texas Code of Criminal Procedure. And your confinement was probated for a period of 15 months. The state has filed a motion to revoke your probation. In this motion, it alleges that you, Chase Wade Ellis, committed the offense of evading arrest, detention on or about the 16th day of January 2023 in the county of Orange, state of Texas, against the peace and dignity of the state in violation of condition number 1. Now, condition number 2, allegation number 2 alleges that you, Chase Wade Ellis, failed to report Jefferson County Probation Office ordered by the court on December 29th of 2022 as directed in violation of condition number 4 of your probation order. Allegation number 3 alleges that you, Chase Wade Ellis, failed to pay court-assessed fees as ordered by the court. And as of January 20, 2023, you were $297 in arrears in violation of condition 8 of your probation order. Allegation number 4 alleges that you, Chase Wade Ellis, failed to perform community service hours as required by the court in violation of condition 14 of your probation order. Allegation number 5 alleges that you, Chase Wade Ellis, committed the offense to possession of controlled substance, penalty group 1, and unlawfully carrying a weapon, in that on or about the 20th day of August of 2023 in the county of Orange, state of Texas, in violation of condition number 1 of your probation order. Allegation number 6 alleges that you, Chase Wade Ellis, failed to report to the Jefferson County Supervision and Correction Department as ordered by the court for the months of May 2023, June 2023, July 2023, in violation of condition 4 of your probation order. Now, Mr. Ellis, if the court finds that any one of these allegations are true, the court can revoke your probation. If your probation is revoked, you can be assessed a punishment up to 90 days confinement in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, as a defendant in a criminal case, you have a right to have an attorney.
Father has been representing me, currently in ICU for critical condition, so
Okay,
otherwise he'd be here.
okay, let me do this here. Ms. Mosley, could you get him a document that's titled Judge's Explanation of Rights to Defendants Without an Attorney? Okay, Mr. Ellis, your bailiff is handing you a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. I'm going to go over this document with you. And this document states as follows: as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you waive your right to an attorney, you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcomes for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time, and you may request that an attorney be appointed to represent you. At the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire an attorney, you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to represent yourself, that is to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name at the bottom on the line that is titled defendant, and you will date it today's date, January 31st of 2024. Do you understand?
Yes, sir.
Okay. If you like, you can go ahead and make your choice. Just hold on a minute. Okay. Let's see. Thank you. Okay. So, Mr. Ellis, you want your case reset to give you opportunity to hire your own attorney. Is that correct?
Yes, sir.
Okay, Mr. Ellis, your case is going to be reset by our court coordinator. Once your case is reset, you'll be free to go and you have a blessed day. What is that reset date?
Thank you, Judge.
April 10th.
Okay, your case is going to be reset to April 10th.
April 10th.
Next case is Kevin Glenn Hebert. Cause number 23CCCR 0728. Mr. Hebert, your full name is Kevin Glenn Hebert. How you doing, Mr. Hebert? That's good. Now, Mr. Hebert, you're representing your case by your attorney, Attorney Langston Adams, who is appearing via Zoom. Mr. Adams, how
I'm
are
here,
you doing?
Judge. Doing well.
Mr. Adams, what is your announcement in Mr. Hebert's case?
Just if you can give me just one reset to complete discovery and investigation in this case, I'll be ready.
Okay, give us a reset date.
April 15th.
Okay, this case will be reset to April 15th. Mr. Hebert, Your attorney will be sent notice of this reset date, your attorney and your bondsman. You're going to get a copy of your reset here in court. Once you get a copy of the reset, you're free to go. And court was informed that you were involved in an accident.
Yes, sir, I got
Is
my
that correct?
paperwork right here.
All right. We hope that you have a speedy recovery, and we'll be praying for you.
Thank
Okay.
you. Thank you.
Just have a seat in that first chair on the wall.
Thank you, Your Honor.
You're welcome.
Thank you, Judge. All right.
Okay, you're welcome. Mr. Hall, you have another case?
Yes, yes,
Okay, you're working on, okay.
yes.
Back in session and cause number 23CCCR 1708. Case is style of state of Texas versus John Edward Toops. Mr. Toops, would you please raise your right hand? Mr. Toops, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Toops, you may put your hand down. How are you doing, Mr. Toops?
Good, right?
I'm doing fine. Now, Mr. Toops, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Let me do this. I'm gonna hand this back to you, Mr. Toops. Could you hand, Mr. Huber, could you hand this back to him?
Yes, sir.
There's a line that has a check mark on it. You're supposed to place your initials on that line. Okay, you finished?
Yes, sir.
All right. Now, Mr. Toops, first document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line stating that you would like to apply for a court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Indigent. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Toops, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Toops, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will also be given information to contact him. Court coordinator is going to give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Yes, sir. Thank you.
I have. Next case is cause number 23CCCR 1800. Case is style of state of Texas versus Michael Vergara.
He's present, Your Honor.
Okay. Who's the prosecutor? Oh, yeah. Oh,
Let's get this one.
Two, three, CCCR 1800.
Somewhere here with- let's go. This just says-
Let's see. The abandoning it, that's my paragraph.
Yeah.
Okay.
Donna Wallace, go ahead.
Hmm. You know what the court clause is in this case? 392. Jefferson County Code at Law number 2 is back in session. The court is in session at cause number 23 CCCR 1800, case to style the state of Texas versus Michael Vergara. Mr. Vergara, is that your full name?
Yes, sir.
You got, Mr. Vergara, would you please raise your right hand? Mr. Vergara, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Vergara, you may put your hand down. Mr. Vergara, how are you doing?
Pretty good. So,
I'm doing fine, thanks for asking. Mr. Vergara, you're represented in your case by your attorney, Attorney Willard Hall. Attorney Hall, do you waive a record in Mr. Vergara's case?
Yes,
And again, Mr. Hall, how are you doing?
doing great.
State is represented in this case by Attorney Erica Porter. Again, Ms. Porter, how are you doing? Mr. Vergara, I have before me a document that is titled Misdemeanor Plea Admonishments. Well, let me back up. I have a document that is titled Information Sheet. In this information sheet, which was filed by the Jefferson County District Attorney's Office, it alleges that you, Michael Vergara, on or about June 24th of 2023, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of DWI of driving while intoxicated. However, the state has abandoned the enhancement paragraph, and by abandoning the enhancement paragraph, you are now being charged with a Class B misdemeanor, which is a lower offense. Do you understand that?
yes, sir.
Now, do you understand what you've been charged with?
Yes.
And to discharge Class B misdemeanor, driving while intoxicated, how do you plead guilty, not guilty? No contest.
Guilty.
Now, you're pleading guilty freely and voluntarily,
Yes, sir.
and are you pleading guilty because you are guilty?
Yes, sir.
Okay. You have to check the box that says DWI first. Erase the one that has Class B. It is a Class B, but it was the wrong box that was checked.
Yes.
Okay. Thank you. Okay, Mr. Vergara. I have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes, sir.
Now you notice some writing on this document. It says the state, first of all, it says the state abandons the enhancement paragraph. That means that you're not being charged with a Class A, you're being charged with a Class B, DWI. And under the Class B DWI, which is this box that's checked, the range of punishment is minimum of 72 hours to maximum of 1 year to a maximum of 180 days in the county jail, a fine that does not exceed $2,000. Do you understand the range of punishment of Class B misdemeanor?
Yes.
DWI. All right. Now, on page 2 of this same document, there's a signature on a line next to a box that's checked guilty. Did you place your signature on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, it's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Now, Mr. Lagarde, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
Yes,
And did you read and understand everything in these documents?
yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Vergara, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1
Yes,
into
Judge.
evidence?
Yes, Judge.
Any objections, Mr. Hall?
No objection.
No objection. State's Exhibit number 1 will be admitted. Mr. Hall, you advising counsel, Mr. Vergara, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Vergara, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Vergara, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Judge.
And what is that agreement?
In exchange for the defendant's plea of guilty, the state is offered 1 year deferred, $500 fine, 60 hours community service, court costs, CW education, and general.
Okay. Mr. Vergara, the state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You'll be required to pay a DPS fee or fine of $100. You'll also be required to pay a fine of $500. You'll be required to pay court costs of $392. And you'll be required to pay probation fee of $60 a month, your analysis fee $15 a month, and a reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the police shooter. For the evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $173 a month. Will you be able to pay the $173 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own or operate. You'll be required to have a drug and alcohol assessment, and you'll be required to adhere to the other standard terms of DWI probation, which includes attending and completing a DWI education class. Now, Mr. Vergara, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Now, Mr. Vergara, do you have a commercial driver's license?
No.
Okay, okay. Mr. Vergara, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Vergara, you're gonna stand next to your attorney, follow the directions. Well, are you ready now? Or should we have him take a seat? Okay,
Question anyway, Your Honor.
yeah, okay.
He's gonna need an occupational license, because now we've been to court on this, it will be under your jurisdiction.
Okay, well, you just have to file your necessary paperwork, and we take a
Okay,
look at
here's
it.
my question, do we file it in this case, or do I have to file a new case?
Occupational driver's license is civil.
Right,
Okay,
so new case,
it's a civil case.
and it's.
This is a criminal case.
What's under your jurisdiction?
I understand that. But I mean, you just have to file it in the appropriate, just read the statute and, just follow the directions.
All right, and would you grant that without a hearing, or?
Well, I don't make an advance ruling on anything.
You would
yeah.
get a hearing on
Yeah, well, we just look at it and take a look, and if we don't make no advance rulings.
it? I've talked to Ms. Porter, she's not.
Okay, well, we still have to have hearings. All right,
I usually do them in the general.
I understand. Okay. Jefferson County Court at Law number 2 is back in session. Court is in session and cause number M334. Okay, she's not. We're gonna have to wait till the bailiff is ready. But this is a person that's not here.
Yeah, you can carry on.
Okay, this is cause number M334132, case is styled the state of Texas versus Jamie LeBeau. Jamie LeBeau was scheduled to be in court this morning at 9 a.m. for the court's announcement docket at or about 9 a.m. The court's bailiff called the name of Jamie LeBeau at the courthouse door. Jamie LeBeau did not answer. Jamie LeBeau has not appeared in court since the court has been in session. His attorney, Ms. Marva Provo, is here. Ms. Bailiff, would you please call and the name of Jamie LeBeau at the courthouse door? The time now is 10:23 a.m. on today's date, January 31st, 2024.
I'm showing the door. Oh. All right, fine, got him.
Jamie LeBeau's name was just called to get at the courthouse door by the court's bailiff. Jamie LeBeau did not answer. A reasonable time has passed to give Mr. LeBeau an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Same as the bond officer.
That motion will be granted. Jamie LeBeau bond will be forfeited and the warrant will be issued for his arrest. And cause number M334132. And Ms. Provo, you're excused and you have a blessed day. Oh,
Oh. Okay.
next case is cause number M328536. Case of style state of Texas versus Stephen Gilbert. Mr. Gilbert? Stephen Gilbert? You had Stephen Gilbert as being marked as being here? page 2 of the announcement docket.
Oh, you just, I'm sorry, he looks like it's two.
Okay. Next case is, do we have anybody ready?
Hold on one. I don't know.
Stephen Gilbert?
Yes.
Okay, this is cause number M 328-536, case is filed in the state of Texas versus Stephen Gilbert. Mr. Gilbert, how are you doing?
Okay, how you doing?
I'm doing fine, thanks for asking. Mr. Gilbert, you're representing the case by your attorney, Jennifer DeLodge, who is appearing via Zoom. Mr. Lodge, how are you doing?
I'm okay, Judge, thank you for asking.
Ms. DeLodge, what is your announcement in Mr. Gilbert's case?
I'm going to request a reset just because I was exposed to someone who was sick this weekend and I did not want to get anyone in the court sick today.
Okay, Miss, give us a reset date. April 15th of 2024. Ms. Gilbert, you're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you're not, and
That's sweet.
you have a blessed day. I mean,
I kind of want to get this behind me.
well, you have an attorney, your attorney is sick. I mean, I don't know if we can do the thing about her being sick.
Yes, we miss work and that's not good.
Well, yeah, I understand. Let me do this.
It's gonna just look bad.
Okay, I understand. Hold on a minute. Let's do this here. Now, Miss the Lodge, you scheduled to be in court tomorrow for a jail run. Is that correct?
Yes, sir, and I am going to be there for that. I just wanted a day to not be exposed.
Now, you probably won't be able to take off work tomorrow.
Not actually doing 2 days in a row. I mean, I could, but that's not look good.
Yeah, but I
I
mean,
just got this job. It's a career job and I need to.
oh, well, hold on a minute. No, hold on a minute. Hold on a minute. Okay, now, Mr. Lodge,
Yes, Judge.
we have a form here. I think the form is Article 17.18 of Texas Code of Criminal Procedure. whereby you can do what is called a video conference. You can have your pleas or anything of that nature done through video conference. This is a form that you would have to sign. We could email it or fax it to you for you to sign. And since he's in court, he can sign it in court, and the state could sign it in court as well.
Well, thank you, Judge. I appreciate you allowing that.
Okay, yeah, I mean, that's the law. So, just have a seat, and you just have a seat, and we're going to see if we can get this form to her to sign, and then she'll get it back to us. Now, do you want us to to email it to you, fax it to you?
Email it is probably the best.
It'd be best for y'all to send it.
She said, well, she's not in office, so
Okay. Okay, hold on a minute. Let me do this. Don't we know him? Now, she's gonna, our court coordinator is gonna call you to get your email address.
Okay.
All right. And you could, I guess, you could just zoom out right now, and then you could zoom back in.
Okay. Thank you, Judge.
Okay, here you go. Okay, just have a seat.
Thanks, sir.
Okay.
she's coming tomorrow and she's sick. She's not, she said she.
Next case is cause number 23 CCCR 1588, case of style of state of Texas versus Jesse Bahina. Okay, here we go. Jefferson County Court Law number 2 is back in session. Court is in session, and calls number 23 CCCR 1588, case of style of state of Texas versus Jesse Bahina. Mr. Bahina, am I pronouncing your last name correctly?
Yeah.
You said that's fine. How did you pronounce it? What, Bahina? Bahina, okay. How you doing, Mr. Bahina? I'm doing fine, thanks, Max. Mr. Bahina, would you please raise your right hand? Mr. Bahina, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Bahina, you may put your hand down. Mr. Bahina, you're representing your case by your attorney, Attorney Corey Crenshaw. Attorney Crenshaw, how are you doing?
We're doing well, Your Honor. Thank you.
That's good. State is representing the case again. Miss Erica Porter. Miss Porter, how are you doing? That's good. Now, Mr. Bahina, I have before me a document that is titled Information Sheet. This information sheet alleges that you, Jesse Bahina, on or about May 6th of 2023, while you were in Jefferson County, Texas, in a public place operating a motor vehicle, that you committed the Class A misdemeanor offense of DWI. However, the state, you abandoning the enhancement paragraph, is that correct? Now, the state is abandoning the enhancement paragraph, which means that you'll be charged with a lower offense, a lesser included offense, which is DWI first, which is Class B. Do you understand that?
Yes, sir.
Now, Mr. Bahina, to the Class B misdemeanor charge of driving while intoxicated, which allegedly occurred on or about May 6th of 2023 while you operated the vehicle in a a motor vehicle in a public place in Jefferson County, Texas, how do you plead? Guilty, not guilty, no contest? Guilty. Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Mr. Bahina, I also have before me a document that is titled misdemeanor plea admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked guilty. Are these your initials?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
I understand.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
I understand.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Mr. Bahina, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
You did.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir. Correct.
Mr. Bahina, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, would you like to offer State's Exhibit Number 1 in evidence?
Yes, Your Honor.
No objection.
No objection. State's Exhibit Number 1 will be admitted into evidence. Mr. Crenshaw, you've advised in counsel, Mr. Bahina, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Bahina, your attorney, Mr. Crenshaw, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
And has he
Yes,
provided
sir.
full, effective, and competent legal representation?
Yes.
Mr. Bahina, I'll accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of guilty, the state has offered 1 year deferred education, $500 fine, 40 hours community service, court calls, DWI education, and interlock. And the state did take into consideration felony plea that the defendant did take.
Oh, okay. That is not running concurrent or anything, is it?
It is part of
It
the
is.
same transaction,
It's supposed to
Judge.
say, yeah, it is.
So write it on. You gotta put it on here. Chief has to put it. There's a felony case that is running concurrent.
It was reduced to a misdemeanor.
Yes, it was reduced to misdemeanor, but it still was held in felony court, so.
Okay, well. It was a different felony case, but it had a number, right?
Yes.
A cause number, a different, okay, just put the, whatever that cause number on there. It's gonna run concurrent with
Let me
that,
look it up.
Yes.
with that case. It was a felony, that it ran CC with. You said that court costs, what was that court cost?
What was that felony number?
3 DCCR 070.
Okay. That's
23 DCCR.
23 DCCR. Is that 0701?
That's what it was, right? 0.
0701, yes.
Okay. You said that,
Okay.
court cost is 377, right? Let me see, 721.
He's already paying probation fees on that.
Thanks.
So there won't be
Okay,
probation fees.
Okay, thanks. And he won't have a, no urinalysis fee, probably no reimbursement fee either, I don't think. Because they pay a reimbursement fee over there too, right? I think all of that runs concurrent. Okay.
So it's just a fine, the CSR and.
Yeah, but there's
court
a,
costs.
but there's a DPS fine of $100, the standard state fine.
No problem.
All right, let me do this here. That's 977. 977 divided. Is that right? Okay. Mr. Bahina, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a DPS fine of $100, regular fine of $500, plus court costs of $377. Now, it's gonna, now the probation fee in this case, because you're already on probation in the felony case that's running concurrent with this case, you will not be paying a probation fee in this case. And you will not be paying a urinalysis fee in this case because you're also paying a urinalysis fee in the felony case. And you will not be paying a reimbursement fee in this case because you're also paying a reimbursement fee in the felony case. So your total monthly installments, that is the total amount that you will be required to pay each month in this case is $89 a month. Will you be, okay. You know, the other thing is you also be required to pay a DWI initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Do you understand that?
I understand.
Now, your total monthly installments is $89 a month. Will you be able to pay the $89 each month?
Yes, sir.
Okay. Now, you'll also be required to perform, is that 40 hours? Yeah, 40 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You'll be required to attend and complete a DW education class. You'll be required to have a drug and alcohol assessment and adhere to the other standard terms and condition of DWI probation. This case will run concurrent with felony cause number 23 DCCR 0701. Mr. Bahina, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just? And do you have a commercial driver's license? No commercial, okay. And do you accept the state's offer?
Yes, sir.
Okay, Mr. Bahina, I'll follow the plea bargaining agreement that you have entered into with the state. You want him to have a seat?
I'm pregnant now.
Okay. Stand next to your attorney, follow the directions of the clerk and the bailiff. Once you finish following their directions, you're free to go and you have a blessed day. And Mr. Crenshaw, you're free to go as well and you have a blessed day.
Thank you, Judge.
Okay. You can put it in there, Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 23 CCC Aura 0460. Case is style of State of Texas versus Lindsay Castile. Ms. Castile, is that your full name?
Sure.
Ms. Castile, would you please raise your right hand? Ms. Castile, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Castile, you may put your hand down. How you doing, Ms. Castile?
I'm fine. How are you doing, Ron?
I'm doing fine. Thanks for asking. Ms. Castile, you're represented in your case by your attorney, Dustin Galmore. Attorney Galmore, how are you doing?
Good, Judge. Thanks for asking.
And Mr. Galmore, do you waive a record in Ms. Castile's case?
We do.
Ms. Castile, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Ms. Castile, it alleges that you, Lindsay Castile, on or about June 12th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Ms. Castile, do you understand what you've been charged with?
Yes, sir.
And to discharge Ms. Castile, how do you plead guilty, not guilty, no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes, sir.
Ms. Castile, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on the line next to a box that's checked. No content, no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, it is.
At the top of this document, there are 2 boxes that's checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Oh, here it is. I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, it is.
Ms. Castile, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir, he did.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Ms. Castile, are you a citizen of the United States?
Yes, ma'am.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, would you like to offer State's Exhibit number 1 in evidence?
Yes, Your Honor. No objection.
No objection. State's Exhibit number 1 will be admitted into the evidence. The court will also take judicial notice of the court's file. Mr. Galmore, you advised in counsel, Ms. Castile, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Castile, your attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, yes.
Ms. Castile, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. For a plea of guilty or no contest, the state has offered 90 days probated over 1 year with a $750 fine, 60 hours community service, the installation of an interlock device, and DWI first and conditions of probation.
Okay. What is the court cost in this case?
375.
376. 142. Ms. Castile, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a DPS fine of $100. You'll be required to pay a standard fine of $750. You'll be required to pay a probation, required to pay court costs of $377. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, a reimbursement fee of $15. You also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $195 a month. Will you be able to pay the $195 each month?
Yes, Your Honor.
You'll also be required to perform 60 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You're required to attend and complete a DWI education class. You're required to have a drug and alcohol assessment, and you'll be required to adhere to the other standard terms and conditions of DWI probation. Ms. Castile, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Castile, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Castile, did she need to take a seat or?
Yeah,
Just have a seat, and then when the court coordinator is ready for you, she can actually come to a window. And once you finish here, you're free to go, and you have a blessed day.
Thank you, Your Honor.
You welcome.
I just sent you another.
Okay. Let's see who's the other one.
Michael Jackson.
Michael Cole Jackson. Okay. Let's see. Who's the prosecutor in this case?
Porter.
Okay, this is cause number M333882, case of style of state of Texas versus Michael Cole Jackson. Mr. Jackson, is that your full name?
Yes, sir.
How you doing, Mr. Jackson?
Good.
That's good. Mr. Jackson, would you please raise your right hand? Mr. Jackson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Jackson, you may put your hand down. Mr. Jackson, you're represented in your case by your attorney Dustin Galmore. Attorney Galmore, do you waive a record in Mr. Jackson's case?
We do, yes.
Mr. Jackson, I have before me a document that is titled information. This information alleges that on or about November 6th of 2022, while you were operating a motor vehicle in a public place in Jefferson County, Texas, okay, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Jackson, do you understand what you have been charged with?
Sarah did.
And to this charge, Mr. Jackson, how do you plead guilty, not guilty, and no contest?
No contest.
Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Jackson, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked nolo contingere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Sir, it is.
And on the next document, the title trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir, I do.
And I also have before me a document that is titled Discovery Certification. You recognize this document? Do you recognize this document? You can show that to him.
That's when you sign it.
Okay, is this your signature on this document?
Sir, it is.
Okay, now, Mr. Jackson, before you signed and initialed these documents, did your attorney go over these documents with you?
Briefly, yes.
I mean, if he took a long time, a short time, did he go over these documents with you?
Yes, sir, he did.
Did you understand what he went over?
Pretty sure, yes. Yes, sir, I am. I am.
So you understand what he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Jackson, are you a citizen of the United States? State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 into
Yes,
evidence?
Judge.
Any objections? No objections. State's Exhibit number 1 will be admitted to evidence. Mr. Galmo, you've advised and counseled Mr. Jackson. Is there any evidence that he is currently mentally incompetent to stand trial?
Negative.
Mr. Jackson, your attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Okay. Mr. Jackson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, yeah.
What is that agreement?
In exchange for the defendant's plea of no contest, the state is offer 1 year deferred, $500 fine, 60 hours community service, court costs, DWI education and interlock.
I think that's a county court case.
What's the court cost in this case?
392.
Let's see. Okay, Mr. Jackson, state is offering that you serve a one-year deferred adjudicated probation. During the one-year probationary period, you'll be required to pay a DPS fine of $100, standard fine of $500. You'll be required to pay a court cost of $392. You'll also be required to pay a probation fee, $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a other evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $173 a month. Will you be able to pay the $173 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own or operate. You'll be required to have a DWI, to take and complete a DWI education class. You'll be required to have a drug and alcohol assessment. You will also be required to adhere to the other standard terms and conditions of probation. Mr. Jackson, do you understand the state's offer? And do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Jackson, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Jackson, if you successfully complete this probationary period, the case will not result in a conviction on your record. You may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Okay? Just have a seat, wait for your name to be called. Once your name is called by our court coordinator, you'll be free to go. You have a blessed day. Mr. Galmore, you're free to go and you have a blessed day.
Judge, you too.
You're welcome. The prosecutors and give me the clipboard for the gentleman to sign. He can read and sign it.